Welcome everybody, and thank you for joining us today for Keeping the Golden Years Golden. Our topic today is guardianship, and we're happy to have you here today. My name is Kara Burgos, and I'll be one of your presenters today, along with my co-host Linda Hackman from La Crosse County. Just a couple of housekeeping minutes before we get started. We're intending on having this webinar last for approximately an hour. We want to be respectful of your time, so we'll try to end promptly at 1 o'clock. We anticipate having us talk for approximately 45 minutes and then keep some time for any questions that you may have at the end of our session. We will be recording today's session and we'll email you the link afterwards, and we will also make the recording available on our Facebook page as well as our website. If you do have any questions today throughout our presentation, feel free to use the chat button and submit your question. We're going to try to focus those questions or answer as many questions as we can in a more general sense. If you do have specific questions that we might not hit on, you can feel free to email either myself or Linda, and our contact information will be available on the webinar presentation at the end of that, the last slide today. And as a reminder, we're trying to keep this information general. Although I am a lawyer, any information that I do provide will be only in the general sense, and any information given to you is not meant to establish any type of attorney-client relationship. So with those housekeeping notes out of the way, we'd like to jump right in. As I indicated, my name is Kara Burgos, and I am an attorney practicing at Moen Sheehan Meyer in La Crosse, Wisconsin. I've been in practice for a little, almost 27 years with Moen Sheehan, and one of the areas that I do practice in is working with guardianships, both on a private basis with families, and I work significantly with the county, who does process guardianships as well. And with that, I will introduce my co-presenter, Linda Hackman. Linda has been a social worker in adult protective services for the county for almost 30 years and has as one of her main focuses guardianships and protective placement. So Linda, welcome this morning as well.
Hi there.
So as I indicated, we are going to be focusing on guardianship here today. And what is a guardianship? A guardianship is a court proceeding solely in court to establish a guardian for an individual. A guardian is appointed to either make medical or financial decisions or both for an individual who is ultimately called a ward. So many people often talk about somebody being or having a guardian. And again, that is solely a decision made by a court. It does rely on opinions from physicians that a person is incompetent and is in need of a guardian, but a person can only have a guardian if in fact a court has made that decision. And they use the terminology of ward and a guardian. There's also what we call in the law a guardian ad litem. That's a fancy term for an attorney who represents the best interests of a person. Now, oftentimes people will say, oh, he or she has a guardian, and what they actually mean is a guardian ad litem. That person is different. It's an attorney who makes recommendations to the court about the best interests of that person, but does not make any medical or financial decisions on behalf of that individual. So there are several different types of guardianship proceedings in the state of Wisconsin. We have a guardianship of an incompetent adult. We have a guardianship of a minor. We have temporary guardianships. And underneath all of those, we also have what's called protective placement. So the guardianship of an incompetent adult person is necessary if that individual who is over the age of 18 is found to be unable to make medical or financial decisions on their own behalf. That can be the result of many different types of impairments that render that person incompetent. And we'll talk a little bit more about them, but they might include a developmental disability. They might include a disability as a result of a mental illness. They could be incompetent as the result of a traumatic brain injury. So those are the different types of injuries that, the different types of incapacities that might render an adult incompetent. A guardianship of a minor is often used where we have situations where an individual does not have a parent who is capable or unable to provide for the minor, and you have an adult who is willing and able to take on that role till the child reaches 18. Those situations might be where a parent is deceased or is incarcerated, or for other reasons are unable to take care of the minor. So those guardianships are different in the sense that it doesn't require the minor to have been found incompetent. The minor just does not have a parent who is able to assume the responsibilities for the minor. A temporary guardianship is used in the state when it is necessary to establish that guardianship immediately to provide for the medical care or financial care for the adult person who is deemed incompetent. That temporary guardianship can last for a period of time and can be extended for a period of time. But again, it's meant to be temporary, to be followed up either by a permanent guardianship or ultimately dismissed by the court. And protective placement often goes along with the guardianship in that it is used by a court to protectively place an individual, whether that placement is either in the home or whether it's in an assisted living facility, a foster home, or perhaps a nursing home. Those orders are designed to keep the individual safe and to allow the facility to hold that individual there under a court order, even if that individual does want to leave. So you will often see those petitions for protective placement go with a petition for a guardianship, because many facilities want that extra placement order so that they can act accordingly and ensure that the individual placed there is in fact safe. You might also hear a conservatorship, and I know Linda's generally doesn't deal with those because those are more for individuals that probably have an estate worth a fair amount, but it is an action where someone agrees to have a individual kind of look over their finances and who provides assistance with perhaps bill paying, investments, sale of real estate. This person is similar to what a power of attorney would be. However, a power of attorney is not overseen by a court order and not subject to the provisions of a court having overview of that and being able to pull the person in to answer for their actions. So a conservatorship is an individual who is not deemed incompetent because they are in fact saying, yes, I agree to have this individual act on my behalf. They file the documents with the court, and then the court has some oversight authority. So let's talk a little bit of how guardianships work. So Linda, I'm going to ask you to kind of jump in here, because oftentimes when an individual and a guardianship proceeding begins, it often begins with Linda's unit having kind of the first line of defense. So Linda, I'll have you step in at this point.
What my unit that I am working in, it's called Adult Protective Services. And we have like 3 different social workers, plus we have a couple support staff. And what our job is we deal with different emergency court hearings. So there are times that if a person is not safe at home, or if they're having difficulties at home, there is an ability for them to be placed under what's called an emergency detention, which is a 72-hour hold. And it's during that 72 hours that you're going to be able to have a doctor evaluate the person, determine if what is happening with them is something that can be managed with medications or some other type of medical procedure. And other times it may be because they are dealing with a permanent memory issue, or if they've had an accident like a traumatic brain injury, where they're not able to make decisions for themselves. And it's in those cases then that it's necessary to do an emergency protective placement hearing. And there are times that when they come in and emergency-wise, La Crosse County does the initial hearing. If the individual has assets that exceed, it's different for a single person and a couple, but if for a single person, if they have more than $2,000, or for a couple, if they have more than $5,000, then that case needs to be referred out privately to finish up and do a permanent guardianship. But La Crosse County often does the initial temporary guardianship hearing so that the individual is able to move on to whatever alternate placement so they don't need to stay in a hospital setting.
So oftentimes people will contact Linda's department to assess a particular case. These assessments can result from a family having brought in their family member who is suffering from either physical or mental incapacities as a result of, as Linda had indicated, dementia, Alzheimer's, or a physical condition which renders them unable to make decisions. So oftentimes the hospital might be contacting Linda's department to address the situation. Or you may have individual family members who are contacting Linda's unit to say, what can we do? I'm at the point where my mom can no longer care for my dad, or vice versa, or I'm caring for my parent. I can't do it anymore. Is there something that we can have assistance with? And Linda's unit certainly has other available options, but when it comes to the point where an individual is not able to make those decisions, Linda's department is going to step in and address and begin to process that initial guardianship. And it does become very confusing for people at times. They say, well, the county started this, but now they told me that I need to go ahead and find an attorney. And again, that's understandable because the county only has limited assets. And so they want to assure right away that the individual is safe, that there is somebody there that can be appointed legally to make further decisions. But after that, they need to say, we need to be there and use their resources in the same fashion for the next family. So that is why individuals are directed to find an attorney who can help them through the next stage of the process. And there's a period of time in there that you can find an attorney and gather the necessary information. But Linda's department is kind of that first line of defense to ensure that the individual is in a safe placement and that the family member, relative, or in some cases, an independent agency now has the authority to make necessary medical or financial decisions for that person. So again, as we had mentioned, nobody can become that guardian over an individual until the court says that, yes, this is necessary. And the court is going to rely on the opinions of a medical provider. So that's either going to be an emergency room physician, a psychologist, a psychiatrist, someone that can attest to the inability of that individual to make medical decisions on their behalf. So again, as we had talked about, a guardianship order is very specific in providing the authority to an individual, to another adult, to make decisions about another individual. Now, the law uses terms, what we call the least restrictive. And that means that they want to provide an ability for an individual to still hold some rights if they're capable of exercising those, but to ensure that those rights that they are not capable of exercising, they give those rights to another adult to exercise for them. So the rights that an individual, even if they're under a guardianship, may retain may be the right to hunt or fish, perhaps the right to ultimately get a driver's license or to vote in an election. The type of rights that are generally going to be taken away from a ward is going to be those rights that really are impacted by the incompetency of the individual. So making contracts, consenting to their medical care, those types of rights are the ones that are going to be passed to the person who becomes the guardian, or sometimes they can even be shared, which means that the individual who's under a guardianship has the right to make a decision, but ultimately the guardian has to consent to that decision. So it's a little bit of shared rights and responsibilities there between the two. And again, the guardian is always obligated to act in the best interests of the ward. Oftentimes we look to have relatives appointed as a guardian for an individual, but sometimes a relative is not available or doesn't want to be placed in that responsibility. So Linda, maybe you could talk a little bit about the outside individuals, either voluntary or corporate, that both the county and then other individuals use in that regard.
We often work with individuals that are called a corporate guardian, and they are licensed by the state, and so the state oversees them. It's an application process that the corporate guardian needs to go through. But that basically means is that these corporate guardians are paid to be available to make decisions on the ward's behalf. We also do have some volunteers that are willing to take on the responsibility of being a decision maker. Corporate guardians, oftentimes they can have up to 20 to 40. And some corporate guardians have various staff that work with them. And then we also have corporate guardians that work on their own. And so they will work with the state as to how many wards that they are looking at wanting to take on for decision-making purposes. Some of our volunteer guardians, they're going to have cases that are not going to be probably as complex. And oftentimes the volunteers don't also want to deal with guardian of estate issues. And in those cases, those will often go to a corporate guardian to do that. Because in some of our cases that we have, it can be hours, many hours that needs to be put in. If you're looking at having to sell a home, if you're looking at having to clear out a home, if you're looking at having to sell property. So it can vary, but the corporate guardians generally are taking on more complex cases. And if we could get volunteers, we will do that.
And oftentimes, you know, family members, sometimes there's fighting amongst family members as to who wants to be the guardian. And as a private attorney, I say sometimes to families, it's okay that you may or may not want to be the guardian. Sometimes the best option is to have somebody on the outside responsible for dealing with the financial issues, and you just get to be son or daughter or aunt or uncle, because it takes away all of those issues. And we're trying to make the quality of life of the individual under a guardianship the best possible that it can be, and still have some of the rights if possible. And so kind of pulling away family members and having just an individual, whether they're paid or volunteer, be able to just talk with that guardian separate and keep those issues away from family sometimes works and is the best possible solution for those types of issues. And anybody can talk with the guardian. There might be certain restrictions that the court or the guardian put in place to keep certain things confidential, but oftentimes there are family meetings that everybody gets to have a little bit of say and understanding about what's going on with an individual's medical care or financial. Ultimately, the goal is what is in the best interest of the individual that is under a guardianship. And that's what the court is always going to look at, and to ensure that those rights are being protected at all times. So again, Linda and I have been using some terms between medical or healthcare and financial. So there are two types of guardianships and two types of guardians. One is a guardian of the person and the other is a guardian of the estate. So one individual can be guardian of the person and estate of an individual. You can have two separate people who are, one is a guardian of the person and one is a guardian of the estate. Or sometimes there might be a situation where there's no need for a guardian of the estate. Oftentimes, especially cases that might come in through Linda and through the hospital, there's an individual who doesn't have very much in terms of assets, and they just need a decision maker for medical care. And if there are issues related to qualifying for federal or state benefits, nursing home care, that guardian of the person we can put in court orders allows them to have some extra authority without having to go through a guardianship process for the estate. Oftentimes, one of the big issues that come to me as a private attorney is my mother or my father prepared powers of attorney. Why do I need to have a guardianship? And that is a very complex question, but I think probably one of the most common questions that we get. And the reason for that is because a power of attorney can be revoked at any time by the individual who drafted it. So if somebody did do a power of attorney, oftentimes the court will, either through Linda's department or through me, put that individual as the guardian for, because that person selected it at a time, obviously had made the independent decision that this is the person that I would like to make medical decisions on my behalf or financial decisions. So the court will often use that person as a guardian of the person or estate. But when it comes to being placed in a nursing home, assisted living facility, or other type of home that is not their own home, those facilities cannot accept individuals under a power of attorney if that individual does not want to stay there. So those facilities need a court order that a guardian can consent to their placement there. And that goes back to what we talked about initially, that protective placement order. So that is why, understandably, it's confusing, because people thought that they had adequately prepared for issues related to dementia, Alzheimer's, that type of thing in the past, but unfortunately, it's not enough if they need to be placed in a facility. And a guardian of the estate is generally only necessary if there are significant assets that we're talking about. As Linda had mentioned, if there's a home that needs to be sold, if there's other real estate that needs to be addressed, that's when a guardian of the estate is necessary, because you want to have court involvement overseeing all of that to ensure that all of those funds are going to be used for the best interests of the ward. And obviously there are ramifications if that individual does receive federal or state benefits in terms of having to account for those and to ensure that that individual is still able to receive those benefits. So that's kind of the difference between a guardian of a person and a guardian of the estate. And oftentimes one can have the guardian of the person and have a financial power of attorney still be effective, and they won't cancel each other out.
There can also be co-guardians too. So if in the event that you don't want to do that alone, or if you have a brother or sister or husband or wife, there is the ability for you to do that together, as long as you are in agreement with the decisions that you make. And that's the key thing is you have to be on the same page.
And people often ask, am I able to be a guardian if I live in another state or another county and my mother or father live in Wisconsin? Yes, in today's world, with cell phones, with email, people, as long as you are reachable by either a facility or a hospital or a financial institution, that you can make those decisions, you can live in another state or another county. You just have to be available for responding to the needs of your ward, family member, whatnot. So again, it's not exclusive if you happen to live in another area. We did talk about, Linda mentioned kind of where her department usually becomes involved at the outset in terms of a temporary guardianship. That is the ability essentially quickly to establish a court order for an individual to become a guardian. And these are often the types of cases where you have an individual in a hospital setting that needs to be if they're stable enough to move to another setting, we want to get them out of that hospital setting. We know that hospital settings aren't good for anybody unless, it's absolutely for physical needs. So we want to ensure that we can get into court quickly to appoint a temporary guardian and to have that protective placement order so that we can ensure the individual is safe and somebody who is competent is making those next medical decisions in conjunction with doctors and social workers as to what's going to be best for that individual. We try to have those hearings fairly quickly. Linda had mentioned 72 hours that we need to have that hearing. So somebody might be transferred into the hospital emergency room. They are then placed in a room, and then ultimately we have court. Nowadays, with COVID restrictions, court is being conducted video-wise with all the parties available to address the court. At any point in time, an individual who is going to be subject to a guardianship has the opportunity to be heard by the court. This is a very restrictive proceeding. You are being asked to give up rights that everybody has. And so the courts take it very, very seriously as to allowing the individual to be heard, allowing the individual to have counsel, and to ensure that the court is in fact making the best decision based on the information that it is receiving from the medical facility. Poverty is not a reason for having a guardian. Even a developmental disability is not necessarily a reason for a guardian. It is if, in fact, you are unable to make a decision in your best interest that is going to have implications for your health, safety, and welfare. Linda mentioned co-guardians. Another type of guardian essentially is also called a standby guardian. And we use standby guardians in the event that the named guardians are unable to act for any particular reason or unwilling to act any longer. So if there are family members who want to kind of be waiting in the wings, we can have them appointed as standby guardian. And if there comes a time that the current guardians are unable to act, at that point in time, the standby guardian has already been approved by the court, and the court can then sign an order allowing the standby guardian to step in and assume those roles. So the purposes of a guardian. So we have talked about kind of ensuring that those rights that are taken from an individual and given to a guardian, what are they? They are making decisions that the person is unable to make for himself or herself, and giving consent for medical treatment, giving consent for living services, giving consent for prescription services, then exercising rights on behalf of that adult, signing consents, signing various documents with government facilities, acting as an advocate for that individual, especially if we're dealing with individuals who are capable of living in the community. They do not have to live in an institution. So a guardian is there to advocate for what is going to be best for that individual, to allow that individual to function to the best of his or her ability in society. Linda, maybe you can talk a little bit about those types of cases that might come into your unit that are not necessarily from the hospital per se. Maybe individuals calling about either their disabled child who is now going to be turning 18.
We have referrals that come in a number of different ways. I mean, many times our referrals can come in from the family member. It can come in from schools. It can come in from provider agencies. It can come in from Salvation Army. It can come in a lot of different areas. And so what we do is having to look at the least restrictive placement for where a person is to live. A lot of people nowadays can live in their own apartment. with having perhaps some support services coming in, someone to come in with grocery shopping, someone to bring meals to them, someone to come in and clean or help with laundry, or someone to take them grocery shopping, or make sure that they get the medications that they need. And so there's really an array of different services, and there's family care organizations that can help pay for those services so that the individual can live in a lesser restrictive setting. And we have people living in high rises, we have them in adult family homes, we have them in a live by situation where they have their own apartment and then people come in and stop in. And so we have a lot of different people that are under guardianship and sometimes protective placement in various different facilities. And so it's kind of a neat thing that they don't have to, guardianship doesn't necessarily mean that you're going to be stuck in a facility. It's actually more so that you're going to be out in the community of some sort.
And Linda hits right on that primary point that courts have changed over the years, and the legislature has changed much over the years to ensure that a person under a guardianship, number one, that it's necessary, that there is a finding of incompetence, and we'll talk about that in just a few minutes, but that they are in the least restrictive setting consistent with their needs. So it's not based on a blanket, this is what somebody with developmental disabilities, they have this, they should be here. Years ago, unfortunately, we were a society that institutionalized a lot of people, and that wasn't good for anybody. That wasn't good for the individual, and it wasn't good for the rest of society. And so over time, the legislature has tried to catch up with what is best, and they continue to make these changes. As I mentioned initially, the term guardian ad litem, it comes from the legislature that said we need to have somebody else looking at this every year to ensure kind of a checks and balances that the individual is still in that least restrictive setting, that they're not institutionalized, that if they are capable of living in their own apartment or just need assistance maybe living with another individual, that we are checking that on a yearly basis and ensuring that other county departments that are tasked with finding the correct placement for these individuals are doing their job too. And so it's a kind of a level checks and balances, and it has worked well. There are always hiccups, but fortunately we've come a long way in ensuring that the rights of people who are under guardianships are looked at each step of the process. So the main thing that we've been talking about is why someone may need a guardian. There's oftentimes that people say, someone is forgetful, or someone has a disability, I feel they're being taken advantage of, or this person has a mental illness that I don't think they're making good decisions. All of that needs to be looked at under the guise of what the court is tasked with finding. So a court needs to find and make a finding that the person is incompetent. So what are they going to be basing that on? The individual, if we're doing a guardianship of an adult, not the minor ones that I had talked about earlier, the person must be at least 17 years and 9 months so that that order is going to go into effect when they're turning 18 as an adult. And they must have an impairment. The impairment must be one of 4 things. It's either a developmental disability, a serious and persistent mental illness, a degenerative brain disorder, or other like incapacities. That other like incapacities is kind of a catch-all phrase. Sometimes we are unable to, or medical professionals are unable to necessarily categorize what is going on with an individual. Certainly they can do testing to determine, they do neurocognitive testing to determine if a person is suffering from Alzheimer's or other dementia type symptoms. They might frame that other like incapacities. The degenerative brain disorder, that often comes from when someone has suffered trauma. to their brain, and they might have now a traumatic brain injury, or other, they've suffered a stroke, heart attack, that have rendered them also having some type of functionary incapacity regarding their brain function. So in all of these 4 types of cases, the impairment must result in something that is substantial long-term disability. So as I indicated, a physical disability alone cannot be the basis of a guardianship unless that person cannot communicate. If that person is in a coma, for instance, then there can be a guardianship in place. But again, one of these must be testified to by a physician or a psychiatrist that testifies to one of these 4 categories. And in addition to that, the physician needs to testify that because of one of those categories, because of that impairment, the person is unable to effectively evaluate information or to make or communicate decisions about his or her personal health and safety. Or if we're talking about a guardianship of the estate regarding his property. So now there might be, somebody may have a serious and persistent mental illness, yet with the assistance of medication, they are still able to evaluate the information and to make and communicate decisions. But sometimes that mental illness, no matter how much it's controlled by medication, they cannot, and they do have that lack of evaluative capacity. So that is something that the court is going to be finding out information, and that's the purpose of the hearing, as Linda had talked about. The ability, as I indicated, of the individual at any stage of the process to challenge what's going on here. Because oftentimes we have individuals who are in fact have an impairment, who do have an inability to evaluate what's going on, but yet they still have that desire to not have anybody else have any control over their life, and they still have a desire to challenge anything. And they have that right, and that's why we have court, and that's why we have attorneys appointed for the individual and the guardian ad litem appointed for the individual. Because again, it's taking away those individual rights, but the court is going to hear from the professionals who are the medical professionals who say, given everything, this person is unable to make decisions about his or her personal care. And then that inability to make or to properly make decisions creates a serious risk of harm to the person. And then it's going to be different depending upon whether we're talking about a guardianship of the person or a guardianship of the estate. So if we're talking about guardianship of the person, it's unable to meet the essential requirements for his or her physical health or safety, and that serious physical injury or illness is likely to occur because of their inability to make or communicate decisions. So Linda, maybe you can give a couple of examples where that might fit for an individual, maybe who is suffering from dementia or Alzheimer's, living in maybe an apartment by themselves, how that might manifest it and how it might come to you.
Oftentimes, when you have someone that has some cognitive impairments, usually phone calls start to come to us is if the person is more forgetful, or perhaps that they've been found wandering out in the community. For some, it can be because of physical, where they have fallen, and Tri-State or the fire department or police department have come to their house numerous times, perhaps even in the same day, to how many times a month. And our departments are really good at making referrals for us, because sometimes it could be that maybe it's not an adult protective service issue, maybe it's just someone through the Aging and Disability Resource Center that can reach out to try and get them connected with services, whether they're private pay services or whether they may qualify for a family care organization, so that you can put services in and they can still remain in their home. So in those cases, those are kind of the calls that we get. Sometimes it's also the inability to provide for their own activities of daily living. And, you know, and for other times, sometimes it's just, some people just choose to live certain lifestyles. And that doesn't necessarily mean that, that because they're choosing to live a certain way, that we are automatically going to remove them or take them from their living situation. Sometimes it can be just trying to help put services in to improve it.
Right. And Linda's department can do those assessments again to ensure that if a guardianship is not necessary, it's not going to be put in place. But for those types of cases that are, they are there to ensure that that individual's health and safety is met. Because sometimes we have elderly persons who are living alone. They don't have any family that are looking after them. And it's finally come to a point that they're doing the right thing. They're calling 911, but it's not a situation that 911 can respond to every day. And so that's when we need to put in some services, that there's going to be somebody there who can help make those decisions about what that individual needs. In regards to a guardianship of the estate, again, the findings that a court makes are a little bit different depending upon what the issues are. We could have cases where you have an individual who doesn't have a diagnosable necessarily mental illness, but they are being taken advantage of because of perhaps a lower IQ, or perhaps they're at a level of functioning that is not enough to prevent them from being taken advantage of. And in those types of cases I've been involved with, there have been a guardianship of the estate to just ensure that the funds that are available for that individual are always going to be there for that individual. And it's not somebody that's going to be, you know, sending checks to people that ask over the internet. You know, we have all heard of scams across the world where people are asking for money for various things. And there are individuals out there who are taken advantage of. And does it necessarily mean that they need a guardian? No, but sometimes it has reached a point where they're just incapable of acting in their own best interest, that it does reach that level. And so again, the court is going to ensure that they are making these decisions in the best interest of the ward. They're also going to find that there are no other alternatives for that individual, no other training, education, support that could be put in place to avoid this guardianship order. So the court is always obligated to look at those alternatives. And then the finding, you know, we go back to what Linda had just mentioned, that a person's lifestyle and the choices they make, we can't always control those. We can't always go in and say, well, you know, we certainly wouldn't do this. We wouldn't have our home like this. We wouldn't, you know, hoard all these things and make it a fire hazard and essential. But again, does it reach that level that they are not understanding the risks and benefits of what's going on, and they choose this? So a court is going to need, you know, first Linda's department is obviously going to assess that, and then the court is going to assess that to make sure, again, are we putting these restrictions on, and are they absolutely necessary to ensure the safety and the health and the welfare of that individual, and then other individuals that may be in and around there. So again, oftentimes the physicians that are addressing the court in testimony on this are going to do some testing if they have time. Many individuals who are adult elderly patients have had some neurocognitive testing by either their family practice doctor or a referral to a neurologist for testing as to where they might be kind of falling away from their baseline. But oftentimes it might be that they have to rely on the information that comes to them from a police report or from other family members to see at what point is this individual at in terms of their functioning, and where are they at in terms of their ability to have this excuse me, have this be something that's changed with medication, with therapy, with other supportive services? Or is this something that is not going to change? It's going to be a long-standing disability that needs to be addressed through the use of a guardianship. And again, as Linda had said perfectly, the guardianship is based not on the quality of the decision the person makes, but on the process by which he or she makes and communicates those decisions. So again, the incapacity that the courts are going to look at is going to be whether they can understand the information that's being told to them. So for instance, if you have somebody who's suffering from a mental illness, can they understand when the physician is telling them that this medication, if taken appropriately every day, in the form that it's given, that will assist that person in being able to make rational decisions in the future. So whether or not they can even understand that information that's being provided to them by the physician. Can they use that now to then make an informed decision that, yes, I understand that might help me, but I do not want to take it because of side effects, this, that. If they say, well, I don't want to take it, because the person in my head said, don't take it. That's not using the information to make a rational decision. And then lastly, how can they communicate to that? Can they tell the individual that they're working with, a physician, the nurse, that is why they don't want to do what might assist them in being safer or, dealing with their mental illness or disability. So again, we term this when we were talking temporary guardianship and permanent guardianship, but I often explain to people that while it might be permanent in the sense that, yes, it could last forever, it could be such that there may come a time where the disability does resolve itself, and now the individual is able to make decisions on their own behalf and to be able to exercise the rights that were taken from them. That often happens in situations that I can tell from personal experience where there might be a traumatic brain injury, and we might be dealing 5-7 years later where the person has, through rehabilitation, through the brain healing, now reached a point at which they are able to and no longer need a guardian. Unfortunately, those are few and far between, but I have had those types of cases where it's not necessary to have a guardianship anymore. Linda, have you had other circumstances perhaps that?
Yeah, I think some in particular would be if you have someone with like a chronic alcohol condition, is that that once that they are perhaps living a life of sobriety, or if they have a period of time where they're not using alcohol, that actually that they can regain their competency. And then also some people with strokes, that with rehab and therapy, that they can come to the point where they can, become their own decision maker again. You need to still have a doctor that makes that decision, though, that evaluates them and determines that, yes, that they have now improved to the point that they don't need to have a decision maker. And even some of our young people that as they grow and as they mature and learn more life skills, there have been others that have been able to regain their ability to be their own decision maker as well.
I haven't seen any questions pop up into the chat, so I will just think of one that kind of popped into my head. People ask, if a guardianship is established in the state of Wisconsin, what happens if I want to now move my mom down to my brother's in Florida or somewhere else? A guardianship can be transferred. They can be transferred to another state, or you can terminate the guardianship here and begin a new one in whatever state that the individual might go to live in. One thing that needs to be talked about is if an individual is in a protective placement, under a protective placement order, we kind of have a hierarchy, in nursing home being the most restrictive placement, and placement in their own home would be the least restrictive. If an individual is moving from a nursing home at the hierarchy top lower, a guardian can place those individuals without having a hearing in court. They provide notice of the move, but if an individual has to move to a more restrictive setting, a court is entitled to have a hearing on that, and the individual is entitled to be heard as to whether or not they do in fact want to move to a different setting. And oftentimes that can be the case where we have elderly persons in their home. They don't want to leave their home, and the time has come that the care that they have been receiving cannot be provided any longer in their home. So they would have a hearing on that as to that next move or next level up. So Linda, was there anything that you might have thought that is a common question that comes across your desk often?
It varies, I think, with different people. I think there was some questions in the chat, though, that
did I miss them?
I think I saw them. I think someone wanted to know how long it takes to establish a guardianship.
Well, from a temporary guardianship standpoint, you could have a temporary guardian from entry into the hospital. We can be in court within a day or two to establish a temporary guardianship. A temporary guardianship and protective placement order lasts for 30 days. After the 30 days, we need to get into court to establish an order for protective placement, permanent, and a temporary guardianship can be extended beyond the 30 days. However, a protective placement order cannot. So we need to get into court to establish those permanent ones. Generally, we ask people after the temporary to contact an attorney pretty soon thereafter so we can get into court within that 30-day time period. Maybe Linda, if you saw another one in there. For some reason, I'm not finding mine.
Yeah, let me see here. The other question is, if someone is worried about mom or dad's safety or capacity, what is the first step they should take? At what point should oh, maybe that's another, I don't know if this is all in one question. It says, let's see. When should one establish a power of attorney? Yeah, I think these are all different questions that I must be getting them as a run-in. I guess just to start off with the question, if someone is worried about mom or dad's safety or capacity, what I would tell you is that probably one of the first steps is to be able to reach out to the Aging and Disability Resource Center, which you can call at 785-5700, and that's kind of the office that I am, well, when I am not at home, that's where my office is. And it would then have, we have option counselors that would reach out and be able to kind of talk about or figure out what's actually happening with your parent. And the option counselor can also get adult protective services involved. And so sometimes we do a joint visit because the option counselor can talk about services. Adult protective services can actually assess the situation. And if someone is not safe, we do have the ability to detain somebody. But we have criteria we would have to meet in order to do that.
I'm sorry. And as far as powers of attorney, doing that can be done at any time. You want to ensure that you do that when your parents, elderly individuals, are competent. I draft powers of attorney for anybody at any age. They don't become, they're active right away, but you still retain the ability to do whatever you want. But at the moment that you do become incompetent, that individual can take over. So the sooner the better in terms of having and executing the powers of attorney. This way they're in place. Any of the hospital facilities can do a power of attorney for healthcare only. you need to have, the medical facilities cannot do a financial power of attorney. So we do those at our office, but the medical facilities can and do have powers of attorney there that are certainly adequate and will protect the individual moving forward. So I think we probably have reached the end of our time this afternoon. I certainly want to thank Linda for your insights and for sharing this webinar with me. Again, the webinar will be available on our website and Facebook page. I would certainly encourage you to look that over. There's also, there have been another seminar prior to ours, and there will be one on another Friday for future benefits planning for individuals who are reaching the age of receiving federal and state benefits. So again, I thank you for working with us today, listening to us, and again, encourage you to look on our website for any further information or the other resources that are listed for the county. But thank you. Thank you, Linda.
Thank you.